Kindly pass-
Item
21.
21.
Can you pass over for the day, my lord?
Okay. But it goes the after the holidays. 2210. Item 21. Same order. 2210.
Please, your lordship, for item number 9, your lordship, I pray for an adjournment on behalf of MSF Begum, your lordship.
Same thing after 2 days because it's a 17 matter.
Lordship.
Same order. 1510.
Oblige.
My lord, I beg acknowledgement in respect of item number 12, my lord.
12.
12.
This is also 17 matter.
My lord, yeah.
You can accommodate till day after tomorrow.
Can it be after weeks? madam?
No,
Any
no,
day?
it's 2017. We are at
No, that-
great
that is-
pressure.
Day after tomorrow, I'm out of a station. madam.
Day after,
Next day.
day after tomorrow.
No,
Item number
not
12.
15, my lord.
Hmm?
Any other day. 15, I'll be out.
Okay, then 1710.
My lord. Hello.
May I please?
Yes.
Lord, item number 8, my lord. Today I have some, my lord, inconvenience. Can it be taken after Deepavali, my lord?
16. This is 2016
Yes, my
matter.
lord, 16th.
What is this IA for?
I have formed, my lord, my lord, alteration of the order passed by the Honorable Court.
This is the order.
Order.
Item 8. Because this matter has been adjourned a lot of times.
Yes. Lord, in the midst of proceeding, my lord, the SP was directed to, my lord, arrest the petitioners. So we have filed, my lord, IA for recalling the, my lord, order.
But this cannot be recalled. That's why we
Yes.
look at this file.
Yes.
Because there was the court query is that why for taking a false claim, proceeding should not be initiated. After that, the matter has been adjourned. Last time when the matter was listed on
Yes,
10
my
to
lord,
nobody was
just, my
present.
lord, just after, my lord, Deepavali.
You see this? IA? Okay, then 1710.
Can it be after Deepavali, my lord?
No, there is a 2016 and 17 matters. You are finding it very difficult.
Lord, before Deepavali, I have some personal inconvenience, my lord. I had to attend somewhere, my lord, to attend the ceremony.
It's really very difficult.
Just after Deepavali, my lord. On that day, my lord, I will need the my lord.
Lord, if you fix it on hearing day. no?
Okay, then we are fixing it on 23rd for hearing. Both sides are represented. This order will be the writ petition. In view of the issue involved, issue rule returnable forthwith without requiring any press steps to be taken. As the records of the tribunal is received, list the matter for hearing on 23/10/2025.
Deep Lord bless you.
Yes, item 1.
May I please, Lord? Here petitioner is the son of the detainee, my lord. She was arrested on 25/5/2025.
Okay, can you get it by Thursday? To whereabouts, huh? For Mr. S. A. Ahmed, and also for the petitioner, so and so for the respondents. By filing this habeas corpus petition under Article 226 of the Constitution of India, the petitioner has alleged that his mother, namely Muhammad Malika Khatun, page 2, alias Muhammad Malika Khatun, was apprehended on 25/5/2025, and since then her whereabouts are unknown. Next paragraph. Accordingly, we request the Learned Standing Council for the FT and border matters to obtain information from the from the concerned authorities of the Home and Political B Department regarding the whereabouts of so and so alias so and so. Who is against whom an opinion where is the opinion?
Opinion, my lord, page 51, my lord.
51.
The judgment start from page 50. There is no date, my lord, at page 51. The date is here, my lord, below portion at serial number 11. The judgment is declared today, 29th day of March 2010 under
There's no opinion dated 29/3/2010 was rendered by the Foreigners Tribunal, Golaghat, in case number page 50.
Obviously repetition, doctor.
Huh?
Allow to start with obviously.
today itself. And
Next paragraph, to facilitate obtaining of the information, the learned counsel for the petitioner shall serve a copy of the writ petition along with a soft copy of the writ petition to the learned standing counsel for the border and FT matters in course of the day. Next paragraph, the learned standing counsel for the FT matters, FT and border matters is permitted to send a downloaded copy of this order to the competent authorities to elicit information. List on Thursday, 16/10/2025.
oblige.
Item 2.
Yes,
His Lordship, the petition was declared an ex parte foreigner on 28th February 2025.
page,
Uh,
page
Is 26, Your Lordship.
26.
Yes.
Heard Mr. Zaid Khalid, learned counsel for the
Lordship.
petitioner.
The conducting advocate at the tribunal did not communicated anything. In fact, her evidence could not be submitted in the tribunal, and subsequently she was declared an ex parte. Hearing.
Okay. As well as so and so for the respondents. By filing this writ petition under Article 226 of the Constitution of India, the petitioner has assailed the opinion dated, ex parte opinion dated 20 February 2025, page 26. Thereby declaring the petitioner, namely so and so, to be a foreigner post 25/3/1971 stream. Notice returnable. Notice returnable in 4 weeks, extra copies within 2 days. The prayer for bail is a call for the records. The prayer for bail is opposed by the learned standing counsel for the FT matters. Stop, however, comma. considering the projection, made 10 days time to take bail of rupees 5,000 to the satisfaction of friend of police
Border,
border,
Sonitpur.
Sonitpur, Jodhpur. List after 4 weeks on receipt of reports.
Oblige.
Item 3.
May I please, Lordship? My lord, this is a contested case, my lord. Opinion dated, my lord, 11/8/2020, my lord.
Page.
Page, my lord, 79, my lord. And opinion at page, my lord, 82.
Mr. K.U. Ahmed, land counsel for the petitioner. Also heard so and so for the respondents. Opinion dated 11/8/2020. Passed by so and so in case number so and so, PE number so and so. We are declaring the petitioner namely so and so. Following of post 25/3/1971 stream. In view of the inordinate delay in asserting the said opinion, keeping the issue of maintainability open, we should notice returnable on so and so, give a date after 4 weeks. Extra copies within 2 days. Call for the relevant records from the concerned tribunal and the following email address of the learned tribunal. Next, the prayer for bail shall be considered on receipt of records. Next, in the meantime, if the petitioner namely so and so is apprehended, she shall not be deported out of the country without order of the court. The petitioner shall cause production of a certified copy of the order before the Superintendent of Police,
Borbetta.
bracket border, Borbetta, to bring the notice, order to the notice of the said authority.
10th November. 10th November.
Obliged.
Item 4.
Yeah, please, Lord. My lord, the impending opinion at page 44, my lord. The opinion is 24/4/2019. Page 44.
What is the ground?
Ground, my lord, 4 and 5, my lord. I have stated in my petition.
Para 4 and 5.
Yes, my lord. He received the notice, and after receiving the notice, my lord, she filed her WS, and thereafter she could not appear.
But that's not a good ground. Heard Mr. S.A. Ahmed, learned counsel for the petitioner and also for the respondents. By filing this writ petition under Article 226 of the Constitution of India. The petitioner has assailed the opinion dated page 44, 24/4/2019, passed by so and so in case number so and so corresponding to SP inquiry number so and so. By declaring the petitioner, namely so and so, to be a foreigner of post 1971 stream. Notice returnable on so and so. Extra copies within 2 days. Call for the relevant records for the concerned tribunal to the following email address of the learned tribunal. The prayer for bail shall be considered on receipt of records. It's just for that you say, keeping the in view of the inordinate delay in assailing the opinion, keeping the issue of maintainability open. You should notice returnable so and so. Prayer for bail shall be considered on receipt of records. List on so and so.
10th November.
We are not giving any interim protection.
It shall not be reported only.
No, we are not satisfied. Even for that, we are not satisfied with the explanation given.
Item 5.
Obligement.
Because it is 6 years. That's why. Yes,
Yes, may I please Lordship. Lordship, petitioner before Lordship, the opinion is 2016 matter Lordship.
page,
Page is Lordship, main order is page 64 Lordship. And the operative portion is Lordship term.
where is your explanation of the delay?
Yes, Lordship, there are 22 I explain Lordship.
Hmm?
There are 22 of my petition Lordship.
22.
Yes, Lordship. Then there are 20, sorry, there are 21 Lordship. That the petitioner requested that she is fully dependent on her husband who is daily labor, passing their days also. And besides the petitioner to meet up her livelihood and to assist her family, she has gone other step for her livelihood, which was delayed in filing the instant petition lawsuit. After the judgment, the petitioner along with the husband, they left the Dhubri lawsuit. And they are there for 8-9 years lawsuit. When they came in that place, they came to again police is searching behind them lawsuit. Then with the council, they obtain the copy and then they come to the before lawsuit. Matter is
Good
16 matter.
explanation. Same last order. Here the learned counsel is Mr. Dilip Dey.
Yes.
Learned counsel for the petitioner. Opinion is at page 64. Dated 15/12/2016. Passed by so in FT case number so and so. FT case number so and so. D voter case number so and so. If I decline the petitioner to be a foreigner of post 25/3/1971 stream. Rest is same. No interim protection here.
Item 6.
May it please, your Lordship.
Yes.
Ex parte order. Corner matter, Lordship. Ex parte order dated Lordship 22/11/2024 at page 21, Lordship. Annex 1, Lordship.
Page number.
21, Lordship.
You have Mr. R. Islam,
Lordship.
Mr. R. Islam, and counsel for the petitioner. As well as so and so for the respondents. Opinion is at page 21, dated 22/11/2024. This is ex parte opinion.
Lordship. Ex parte order.
Ex parte opinion dated so and so. So and so, FT case number so and so, IMDT reference number so and so. Thereby declaring the petitioner to be a foreigner of post 25/1971 stream. Notice returnable in 4 weeks, extra copies within 2 days, call for the relevant records. The prayer for bail is opposed by the Learned Standing Council for the FT matters. Considering the projection made. Then it's time to take bail of rupees 5,000 to the satisfaction of Superintendent of Police Border, Dhubri.
Dhubri.
Where is the explanation of the delay for not contesting the matter?
Lordship at page number 7, actually, this is within 1 year, Lordship.
That is not.
Page number 7, Lordship at para 7. We have explained, Lordship. Lordship. We have received Lordship notice at on 5/12/2023, Lordship, and accordingly we have appeared on that date. Lordship, after appearing,
But these are grounds.
Let's
Do you believe in that ground?
Lordship, we have tried to explain at page number 7 at para 7, Lordship.
Okay, we have given you bail.
Obliged, Lordship.
Item 7.
Let me judge. Let in due order dated 11/7/2025 at page 79.
79.
Yes, ma'am.
See, we'll give bail here. Mr. M. A. Sheikh, Learned Counsel for the petitioner, and so for the respondents. Page 79. Opinion dated 11/7/2025, passed by so and so in FT case number so and so, reference FT case number so and so. Declaring the petitioner, namely so and so, to be a foreigner post 25/1971 stream. Notice returnable in 4 weeks for the record of extra copies in 2 days. Period for bail is opposed by the Learned Standing Council for the FT matters. 10 days time to take bail of rupees 5,000 to the satisfaction of Superintendent of Police Border, Gwalpara.
Upgraded item 30 with 31.
What is there? Yes, Mr. Mahmood, you are calling your item.
Yes, sir. That yes. We have received the rupees 2 lakhs.
You have received.
Yes.
Okay, then we post it for hearing. Post it for hearing. Will, this is a 2022 matter.
Yes, Lordship.
Will-
November, ma'am.
January, okay. 13th November. Which is represented. Sami Mahmood, Learned Counsel for the petitioner has submitted that as per instructions received by him. Petitioner has received an interim compensation of rupees 2 lakh. Next slide. In view of the issues raised in this writ petition for the issue rule returnable forthwith without requiring any further steps to be taken. List the matter for. Mr. Sharma, just check the records. If everything is there, we require anything to be called. Because when we are fixing it for hearing, thereafter we will not call for any record. If you need the police records or any record, just check it up. as all the records are stated to be available, list the matter for hearing on 13/11/2025. Just check it. Mr. Mahmood, please also you check it,
Yes.
because if any records are to be called, we will call it now, not at the date of hearing.
Item 32 upgraded.
This is also one of custodial death. Police arrested the son of the petitioners, and he was taken to identify the place where the home guard, deceased home guard was killed. At that time, police, where there are almost 40 police personnel, were shot down him and died. Abdul Khalik died on the spot. So in this case also, it's a very clear case.
We'll try to take it up at the end of the day today.
Yes,
We'll take it up, take up the hearing.
yes.
Yes. Because we see we have some notes made here. I think it was heard earlier.
Earlier is a hard one. Get to this power.
Take it up at the end of the day. for hearing.
End of the day today.
After these matters are over.
Yes, yes. 33 also, it is also
Police filing.
police firing.
33 we may not be able to take up today.
Any other day, my lord.
Chal, bye.
We have to take up the hearings. This was heard earlier. Uh, Says are represented. Item 33. Both sides are represented.
In this case, my lords,
This is
some
the-
copies were called for from the court below. Scan copy.
It's available. That's why we are taking up for hearing. Has this case, the allegations in the case relates to death by police firing. The court is inclined to issue rule returnable forthwith without requiring any press steps to be taken. As we find that the matter had been heard earlier. Which is reflected by order dated 27/9/2024. Next para. This is the matter for hearing on same 13/10/2025.
Notes. 13/11.
13/11. 13.
Item 35 upgraded.
Okay. We'll call it later. Nobody's there.
Item 11 for admission.
This. The petitioner remained unrepresented when the matter was previously called on 14/2/2019 and 18/10/2023. Full stop. As per order dated 18/10/2023, it was observed by the court that on failure on part of the petitioner to remain present in the matter on the next date, consequential orders would follow. Next paragraph. Today, when the matter is called, the petitioner remains unrepresented. So accordingly, the petition stands dismissed for non-prosecution. For this writ petition, assailing the page 35, order opinion dated 7/12/2015, passed by so and so and so and so. Stands dismissed for non-prosecution. Next one. The original records of the tribunal shall be retained for a period of 30 days from the date of the order and thereafter returned back to the concerned tribunal. Thereafter, next paragraph, the next paragraph, the learned standing counsel for the FT and border matters, it is at liberty to send a downloaded copy of this order to the concerned authorities in the Home and Political B Department and to the Learned Foreigners Tribunal. Hailakandi. Foreigners Tribunal Roman 2, Hailakandi, Karimganj. No, something is wrong. Just one. Foreigners Tribunal, Hailakandi. Page 35, huh? Oh, you're there? Yes, ma'am. Yes. Yes, Mr. Ahmed.
My lord, as far as this case is concerned, if I go by the merit, my lord, it is on 2 documents or 3 documents they enclosed. The Khatian of 1970, voter list of 1993, and voter list of 2011.
Yes.
In the Khatian 1970, father name appeared, Virendra Das. The voter list of 2000, my lord, 1993, the father name appeared, and voter list of 2011, his name appeared. In one voter list, his name, father name has shown as Virendra Das. Another voter list. Related to result. This must be. থাকলে তো yes.
In neither in your pleadings nor in your evidence,
There is it is my lord admitted, there is nothing.
no, in neither in your written statement nor in your evidence, you have you have stated the name of the village for the village in where this land, where your Khatyan is there, page 15.
Yes, my lord.
The original copy is at page 17. That statement is not there, and you see, the translated copy, page 15, name of the village appears to be in some variance with the
Same
with
criteria.
that in page 17.
No, my lord, Gram Saint Cathedral. Page 17. Saint Cathedral.
Kotharail.
Cathedral. Yeah, I will made mistake in the typing, man. Cathedral.
Whatever we got. But in the absence of any statement in the written statement and the evidence.
Yes, ma'am, that is true, madam. Whether he can be put it under the policy of the government, it is up to them, madam. So for the merit is concerned, there is nothing. Yes, what they say, I don't know, madam.
For that, you'll have to speak to Mr. Sharma. We can't do anything. There are certain things we can't say or hear.
What instruction? What happened?
But you put a document.
Time to look at more engage in what happened instruction.
This, the petitioner who has to submit whatever one they want. First of all, they can never give, take the benefit of car. Take. Because, but it has to come from, even pendency of this petition is not barred for application under the. That doesn't really. But my understanding is saying that he has no connection.
But I don't have any communication with my client. One advocate, he, my lord, giving the brief. So I'm appearing, madam. I have not even seen the client, madam.
Because the connection is not there. If he's resident of a different village, then this Khatian doesn't prove anything. And that also, this Khatian is a secondary evidence. It's a certified copy.
We can take a steps from our one, from our end, we can take a steps to what about this person.
Pardon me?
From our end, my lord, we can take a step through our SP, my lord, to where about this person is, whether he's there or not, because if he has no communication, we don't know, my lord, whether the person is there or not. As of that.
You're not saying anything in the order, you.
Yes, yes,
you
no,
take-
your lordship.
take a call.
I'll-
Just
I'll-
John is-
Yes.
Both sides are represented. On the John Pierce, FKR Ahmed, learned counsel for the petitioner, and Mr. J. Payang, learned standing person for the FT and border matters. Call the matter stands adjourned today. List on 3/11/2025.
Item 13.
Right.
Item 13.
Thank you for the time being.
Fourteen.
May I plead your lordship? Elsewhere received.
Yes, available.
Actually, inform order at page 25.
Yes.
The petitioner is declared as foreigner due to lack of relation linkage. So, records are available. Kindly fix for hearing.
It's ready for hearing. Already the rule has been issued. Already rule has been issued by order dated 17/5/2024.
Then verification officer conducted verification, giving visit in the house of the petitioner. And in the verification report, he stated the date of birth of the petitioner is 1961 and his place of birth is Nalia Part 2. And her father name is mentioned late Ahmad Ali and her husband name is mentioned as Asiruddin.
Those issues are
During
already
the
settled.
time of inquiry, she produced the voter list of her father, 1966 voter list. And 66 voter list, 1966 voter list is containing the name of her parents. His father's name is Ahmad Ali and mother name is Sumarjan Bibi. Exhibit 1. And Annexure 3, page 21.
Yes.
Then she also produced a voter list of 1970, Exhibit 2, containing the names of her parents at village Naliapattu. Thereafter, she also exhibited voter list of 1994 as Exhibit 4, containing her name at village Naliapattu. Thereafter, she also exhibited the voter list of 2016, Exhibit 6, containing her name. she also exhibited linkage certificate dated 09 oblique 097 15, exhibit 3. 0907 2015, exhibit 3. Concept certificate. She also examined as DW1 and her younger brother, Safar Ali, examined as DW2.
What is the name of the brother?
Younger brother, Safar Ali. He was cross-examined. Annexure 3, page 27.
He is DW2.
DW2. Safar Ali as DW2.
His evidence is at which page?
His cross-examination at page 23, but his evidence he is not annexed with the petition, and that is on record. And moreover, she also filed an additional affidavit that her name is included in the draft CITA after the death of her father. But that document was given to the Angus advocate, but he had not produced during the trial. And that draft CITA is at phase as an annexer, additional affidavit at phase 5. Her name is recorded there in place of her father, Ahmed Ali. And her name is mutated in place of father on 27/1/91. Copy of draft CITA, Annexer 11.
You have not exhibited voters list of 1997.
No, my lord. Her name is, in 1997, her name is, and a deep mark has been inserted against her name,
D-mark.
D mark.
Where is that?
I have expected in my, but I have not annexed or exhibited. She was entered into marriage one Asiruddin at the same village, Nalepar.
Is any document of your projected brother DW2 available?
DW2, only I have exhibited. I have annexed draft sheet in my additional affidavit, but it has given to the advocate, but it has not produced before the tribunal. Properly here in my additional affidavit, kindly see page 4. Here, as a successor in place of Patadar Nong 2 is Ahmad Ali, MD Zainal Abidin, Mayan Ali, Safar Ali, late Ahmad Ali, son of late Ahmad Ali, Kanson Bibi, wife of Sattar, Modhmala, wife of Asiruddin, Fulmala, daughter of late Ahmad Ali. Again, next, as a successor in place of Patadar 2, Zainal Abidin, Mayan Ali, Safar Ali, Fulmala Khatun, late son of late Ahmad Ali, Kanson Bibi, Sattar Modhwala, wife of 15. In my additional affidavit, draft sheet, there all of them he was cross-examined. She explained that his father has two brothers, Muhammad Ali and Ahmad Ali. His mother name is Surul. Mother name is Surman Jannes Bibi. He was married to one Asiruddin. And DW2,
I'll ask you a question. Please give a frank answer when he asks that. Will you be surprised if you find that the judge in any court is more intelligent than you? Forget about the case. Will you be surprised to find that a presiding officer of any court, maybe Munsif, maybe CJM, maybe Judicial Magistrate First Class, is more intelligent than you? Will you be surprised?
Sometime it may, sometime it may not be.
No. Will you be surprised? Question is, will you be surprised or you will not be surprised?
No.
You will not be surprised. You see, you made a statement in the court that that the petitioner gave the copy of draft chitta to his lawyer.
Yeah.
Correct? Do you stand by that statement? You made a statement before us that your advocate, that the petitioner gave that document, draft chitta, to your counsel. Do you stand by that statement?
No, but it was,
Please tell me whether you stand by that statement you made at the bar.
no, I have not stated, I have only stated that,
Your submission before this court was, this is for the third time I am repeating. Your statement was that that the petitioner gave this document to her advocate. My question to you is, do you stand by that statement?
not in this,
Not.
at present.
So why you made a false statement before the court, and why we should not send your case to the disciplinary committee of the Bar Council?
My lord, it is explained to me by the petitioner,
That's why
but I have not written that in my, I have only written
no,
here.
if you were told by the client, why don't you stand by that statement?
Why, this is, I have given this oral statement, by have, it is
You
not.
gave us an oral statement. Please think over very, very carefully and give your answer. Why we should not send your case to the Bar Council for drawing up a proceeding, for making a false statement before the court, knowing it to be false?
Sorry, my lord.
Not sorry. You will respond to the question, why your case should not be sent.
My lord, I have only orally submitted, but I have not.
That's why we started asking question. Will you be shocked to find that a presiding officer is more smarter than you?
Yes, my lord.
You will be shocked.
Sure.
Then you don't have to worry. We'll send your case to the Bar Council. We'll see that
My lord,
the steps are taken against you.
my lord, I beg pardon, my lord.
We will dismiss this petition on that ground, and we will ask the Bar Council to draw up a proceeding against you.
No, my lord, parties should not be sufferer.
Parties would not suffer. Parties will get the result of what the argument you made.
I have actually.
But you will suffer for the false statement made before the court.
I was they tell me that I have given.
Okay. So we expose your false statement. Since you are repeating for the third time that this was told to you by your client, we'll show you, we'll demonstrate before you why your statement is false. This, according to this file, the writ petition was filed on 26/5/2017.
Yes.
Your page 5 certified copy was obtained on 3/10/17 after filing of the writ petition, and you still say that your client told you that this document was given it to the lawyer. Nothing can be more false. You have made a false statement knowing it to be false. The document itself was procured after the opinion, and you make that statement. And when we say that, will you be surprised that a presiding officer is smarter than you? You say yes. You are surprised that somebody else is smarter than you.
That 10/8/17, it was
Applied for
applied for
after the opinion.
after the opinion, but they say I have not.
I understand you are fool. You don't have the basic knowledge of reading the document. You are doing a disservice to the clients for whom you are holding the brief. You are not fit to be here. We have warned you for the third time that you are making a false statement, knowing it to be false. And then you start making stories. You don't deserve to be here. You don't deserve to be here. We'll see that your case is taken up by the Bar Council.
I beg pardon, my lord. I have
No, we can't. We have given you thrice, warning 3 times. You should have been smarter. But you are shocked that the court is more smarter than you.
Yes. My lord.
You suffer the consequence. Don't make ever a false statement before the court.
Okay.
When it can be exposed, not even by reading the document, by a prima facie looking at the document when you find it that the contents are false.
Okay.
Heard. Mr.
P. Ahmed.
K. Ahmed,
P. A. Ahmed.
T. A. Ahmed, learned counsel for the petitioner. Also heard so and so for the respondents. Six of the Constitution of India, the petitioner namely so and so, page 2, Madhumala Bibi, has assailed the opinion dated 18/3/2017, passed by the London member, Foreigners Tribunal 8th, Dhuvri. At page 25, huh? Case number so and so, FT case number so and so, reference IMDT case number so and so, thereby declaring her to be a foreigner post 25/3/1971 stream, who has entered into India within bracket Assam without authority and valid documents. Next paragraph. The learned counsel for the petitioner has submitted that apart from the exhibited documents, the petitioner had handed over to her learned counsel who was holding the brief for her before the Learned Foreigners Tribunal, a copy of the draft chitta with regard to a plot of land covered by doc number 180/60 and doc number 168/75/253, which is more fully described in annexure 11 appended to an additional affidavit filed by the petitioner on 6/5/2019. But the said document was not produced before the Learned Tribunal. Next. In brief, the case of the petitioner is that upon receipt of notice of the proceedings, the petitioner had appeared before the Learned Tribunal and filed a written statement and examined herself as DW1 and had exhibited the following documents. This you will get at page 26. Number one, voters list of 1966, within bracket exhibit 1, voter list of 1970, exhibit 2. This exhibit 1 and 2 are of village 207 Nalia NALIA part Roman 2. 1970 is also same. Then Panchayat certificate dated 9/7/2015 within bracket exhibit 3. Voter list of 1994, exhibit 4. Ration card number 1839905. 1839905, huh? Exhibit 5. Printed voter list of 2016 within bracket exhibit 6. Copy of elector photo identity card within bracket exhibit 7 of her son, namely Mataleb, MATALEP, Mataleb Sheikh SK. Electoral photo, photo identity card of her son within bracket exhibit 8. Sohan, S-O-V-A-H-A-N. Sohan K, S-O. Electoral photo identity card of her son. Ourachand, O-U-R-A-C-H-A-N-D, one word. Ali, within bracket exhibit 9. Full stop. Moreover, next paragraph, moreover, the petitioner has also examined her projected brother, namely Safar Ali, SAFR, Safar Ali, as DW2. Well, comma, who had not exhibited any document. So the learned tribunal had discarded the exhibited documents on the ground that there was no documents for linkage of the petitioner with Ahmad Ali, Ahmad Ali. And it was further opined that the exhibiting of the voters list without proving the contents thereof with the linkage to the petitioner cannot be accepted for proving the claim to citizenship of India, and accordingly as no supporting documents were found, and the other documents pertain to beyond the cutoff date of 25/3/1971. The said documents were not found sufficient to prove the citizenship of the petitioner. And accordingly, she was declared to be a foreigner post 25/3/1971 stream. Next paragraph. The learned counsel for the petitioner has asserted that the name of the petitioner's father is Ahmad, Ahmad, Ahmed Ali, and that her mother's name is Surma Jan, Surmajan Bibi. And that their names appeared in the voters list of 1966. In the bracket exhibit 1 and voters list of 1970 within bracket exhibit 2. Both of 35, Golagganj constituency, the village number 207, Nalia, 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 part 2. Referring to the writ petition, it is submitted that the petitioner, due to poverty, did not go to school and was married to one Ashiruddin, Ashiruddin, Sheikh of the same village. And thereafter, her name was recorded in the voters list of 1994. Within bracket exhibit 4. The lands has been placed on the Gram Panchayat certificate issued by the secretary, Nalia Gram Panchayat, countersigned by the block development officer, Rupsi, within bracket at exhibit 3. Stop. It is also submitted that the testimony of the petitioner regarding the name of the parents and the name of the grandfather of the petitioner was not challenged by the state by way of cross-examination, and therefore the unrebutted statement of the petitioner that she was the daughter of Ahmad Ali and Surma Jan Bibi, alias Surmadan, Surmadan, Beva, and that her grandfather's name is P-E-E-R-U, Sheikh S.K. Established that the petitioner is a citizen of India, was born before 1966. It is stated that in the written statement, the petitioner is referred to the disclosure of 6 siblings, including herself, Kanchan Beva, K-A-N-C-H-A-N, Kanchan Beva, Joynal Abedin, Joynal, Mayon Ali, Mayan Ali, Fulmala, within bracket deceased, and Safar Ali. In support of the submissions, in the writ petition, the petitioner is referred to the full bench decision of this court in the case of State versus Muslim Mandal and others, 2013, within bracket 1, bracket close, GLT 809. Again, give a paragraph, bracket para 122.1 and 122.2, as well as the case of Sarvananda Sonwal versus Union of India and others, within bracket 2007, bracket close 1 SCC 174, within bracket para 55. Full stop. Moreover, it is also pleaded that the Supreme Court of India, in the case of Rofik, ROFIK, and another versus Munsilal, MUNSILL, and another, within bracket 1981, bracket close 2 SCC 788, has held that the litigant should not suffer due to the fault of the engaged counsel. Project that the petitioner is a victim, partly because of the act of a engaged learned counsel. Next, you are relying on any citation or any more submissions you want to make?
My lord, she has established her linkage in the way of her cross-examination.
That we have already mentioned in our dictation, we have already mentioned.
Yes, my lord. I have nothing to say.
Okay. Stop. No other submissions was made by the learned counsel for the petitioner. Next, para. Per contra, the learned standing counsel for the FT and border matters has supported the impugned opinion. Next, para. At the outset, you make a mention that the learned counsel for the petitioner has made a false statement before this court, or knowing it to be false, by asserting that the copy of draft chitta, which is annexed to the additional affidavit filed on 8/5/2019, was handed over to the learned counsel for the petitioner before the Learned Foreigners Tribunal. Stop. Query of the court was posed on 3 occasions for the learned counsel for the petitioner to take a stand as to whether he stands by the submissions made at the bar. Full stop. As the statement was sought to be explained and reasserted, the court is inclined to make an observation that the certified copy of the draft chitta was applied for on 10/8/2017 and was made over to the applicant on 3/10/2017. These dates are relevant because of the fact that the opinion by the learned tribunal was rendered on 18/3/2017, and this writ petition was filed on 26/5/2017. Therefore, the said document was applied for and made over to the applicant on 3/10/2017, and thereafter the additional affidavit was filed on 6/5/2019. Full stop. Therefore, the court was inclined to put the learned counsel for the petitioner to notice as to why, for making a false statement at the bar and before the court, knowing it to be false, why his matter should not be referred to the bar council of Assam, Nagaland, etc. Full stop. The reply not having been found satisfactory, the court is inclined to drop a supplementary interrogatory application for this issue to be dealt with separately. Next para. In the present case in hand, there is it is noticed that as per the voters list of 1994, within bracket exhibit 3,
Certificate of govern.
and exhibit 4. The age of the petitioner is known to be 33 years, which makes her date of birth sometime in the year 1961. And therefore, the age of adult franchise at the relevant point of time was 21, there's no explanation as to why the name of the petitioner did not appear in any voters list immediately after 1982 till her name had first appeared in the voters list of 1994. Full stop. The the certificate issued by the secretary of an Aligarh Panchayat within bracket exhibit 3 was not proved by examining the author of the said document. Therefore, exhibit 3 cannot be said to have been duly proved in accordance with law. The DW2 in his cross-examination has stated as follows. give a dash, make it a subparagraph. Inverted commas started. OP is my elder sister. Comma regarding pain. Where is the cross-examination you said was available here?
Cross-examination is 23, page 23.
Page 23. Huh? Comma regarding ascertain my sister, I have not produced any documents with my evidence today. Full stop, invert comma closed. Page 23. Next paragraph. As per the deposition of the DW2, namely Safar Ali, comma, his age was 41 years as on 6/1/2017, and therefore his year of birth would be sometime in 1976. Would be in the year 1976, not sometime. And therefore the age of adult franchise being 21 at the relevant point of time, comma, the name of the DW2 ought to have appeared in the votosis after 1997. However, no document has been proved by the petitioner to show that DW2 is her brother. Full stop. Next paragraph. Therefore, comma, the linked document within bracket exhibit 3, which is the certificate issued by the Gram Panchayat, comma, having not been proved in accordance with law, comma, loses its efficacy as a reliable and admissible evidence to prove the link of the petitioner with her projected father. Next paragraph. The stand of the learned counsel for the petitioner that the unrebutted cross-examination, the non-rebuttal of the evidence of the petitioner that she was the daughter of Ahmad Ali, comma, son of Piru Sheikh, having not been questioned in the cross-examination, comma, is a due evidence. Stop. In this regard, the court would like to refer to the decision of this court. Where is that judgment that oral statement is not evidence in FT cases? But just leave a gap. Oral evidence does not prove citizenship. Give it after some time. Just giving it, leave a gap there. Full stop. Accordingly, in view of the no, not accordingly. You say next paragraph. Coming to the decisions cited in the writ petition, being the case of Muslim Mandal within bracket EPRA. Just take a short break and come back.
Bijoy Das.
Bijoy Das.
Yes. There are certain.
Bijoy Das versus State of Assam and others. Union of India and others, 2018 within bracket 3 GLT 118. The next paragraph. With regard to this, the we are referring to Muslim Mandal. This Muslim Mandal would be State of Assam versus Muslim Mandal and others. Spelling is MOSLEM, Mandal MONDL and others. With regard to Swensu, the petitioner placed reliance on paragraph 122.1 and 122.2. The said paragraphs are quoted below. Next paragraph. In the present case in hand, the petitioner has not been able to prove her linkage to her projected father. And there is also no pleading with as to what happened to her projected parents after the name appeared in the voters list of 1970 within bracket exhibit 2. So there's total absence of any pleading as to whether they were alive or not on the date on which they had expired. Stop. Therefore, comma. The name of the petitioner having appeared in the voters list of 1990. For the first time. Cannot be accepted to be a due proof of the petitioner being able to establish herself with her projected parents or with her projected grandfather. First, according to the ratio laid down in the case of Muslim Mandal within bracket Supra, does not appear to help the petitioner in any manner. For the same reason, the paragraph 55 of the case of Saravanan Sonwar within bracket Supra also does not help the petitioner in any way. Next paragraph. The petitioner places reliance on the decision laid down in the case of Rofik, R-O-F-I-K, Rofik, and another within bracket Supra. Full stop. In this case, the petitioner has not been able, neither the petitioner nor her learned counsel had been able to satisfy the court that the petitioner had suffered any wrongdoing on part of her engaged counsel. Therefore, comma. Court is unable to accept that the petitioner had been made a victim partly by any act on part of her engaged counsel. Full stop. Apparently, comma, the petitioner has not moved the appropriate authority company to decide about the wrongdoing, comma, if any, by a engaged counsel. This court is not an authority to decide as to whether engaged counsel before the foreigners tribunal had done any act which has caused any prejudice to the petitioner. Full stop. Therefore, the said case of Rafiq within bracket Supra also does not help to espouse the cause of the petitioner in any way. Next paragraph. Accordingly, the court is unable to find any privacy fault in the opinion impugned in the present date petition. Full stop. This court is conscious of the fact that in entertaining the challenge to the impugned opinion dated 18/3/2017, the court is exercising statutory jurisdiction. And therefore, unless gross illegality can be demonstrated on the face of the accord, the court is prohibited from substituting its wisdom upon the opinion rendered by the learned tribunal. Next, accordingly, this writ petition fails and the same is dismissed. Next, there shall be no orders to post. Next, the registry shall register an interrogatory application in terms of the directions contained in this order and list the same after the same is registered. Let the registered case in this disposed of writ petition. Next, the records of the tribunal be returned along with a copy of the order we made a part of record. Next, the consequences of the opinion would follow.
Item 15.
My lord, 15 is writ petition filed by the state, my lord. In this case, my lord, the written arguments have been already filed.
Yes. But you have to make your submissions. Because this week we are not hearing it.
Yes, my lord.
But again, there will be 3 days of holidays. We have some engagements. We'll take it up after after 21st, whenever it is convenient to both of you. When, give a date, we'll fix it on that day.
21st, after 21st.
After 21st, because
Yes.
the
November. October. October 21st. 21st পিছত 21st পিছত 28, 29, and 30.
okay, 28 then. What says it you are represented? It appears that the written note of submissions on behalf of the petitioner and the
Both sides.
Um,
is fine.
the petitioner and the respondent have been filed. Full stop. As recorded in the order dated 20 April 2024. Next paragraph. As the records are available, court is inclined to issue rule returnable forthwith without requiring any fresh steps to be taken. Next, paragraph is the matter for hearing on 28/10/2025.
16.
Yes,
My lord, this case was earlier heard by this honorable court. My
you
lord.
understand that.
My lord. My lord, para 13 and 14, and it's a 1, my lord.
Para
Para 13 and 14, my lord,
of the writ petition.
of my petition. My lord. The grandparents' name was in this total list, my lord. 14. My lord, page 13 and 14, sorry, my lord.
Page
Page
13 and
13 and
14.
14. Page 13 and 14. Annex 1, my lord.
Which page is the opinion?
Opinion is the, my lord, page, my lord, 28, my lord, Annex 8.
Page
Page 8, the 28, Annex 8,
28.
page 28. 28. Para 6, my lord, may perish. In support of the case, PDW1, her father, namely Abdul Nur Borbia, alias Abdul Nur, is also present in the court and gave his deposition as DW2, supporting of the Indian nationality of his own and the OP herein.
If I remember it correctly, I don't know, I may have forgotten. I think Aziz Mia.
My lord,
Aziz Mia is the case where it has been laid down that oral evidence would not be sufficient to prove citizenship. Is it right, Aziz Mia?
No, Lordship. This is regarding voter list, Lordship. Vijay Das case is clear, Lordship.
Vijay Das.
Vijay Das. Vijay Das, Noor Begum. Noor Begum in respect of mother, Lordship. Mother's oral evidence.
You see, we are asking you this, you. In the repetition, have you filed your, where is the written statement?
budget statement is, my lord, page 25, my lord, Annex 7,
Page 25.
page 25, my lord, Annex 7.
Now please see paragraph 10 at page 26. The name of your father, you say, is Abdul Noor,
My lord,
correct?
my lord.
Now, in the evidence of DW2, have you
Hello.
annexed that DW2?
My lord.
Is it annexed here? No,
DW2 is not annexed, my lord.
DW2 is not annexed.
It is in this year.
You have a copy of that DW2?
Presently not, my lord.
DW2 was your brother,
Yes, my lord, I have the copy, my lord.
and you say that your father was present. He was DW,
2, my lord,
DW2.
my lord.
No, DW2, I don't know what has happened here. Look at this. No, you have a copy, okay. Now you look in this DW2,
My lord,
your father says his name is Abdul Noor Borgnia, alias Abdul Noor,
my lord.
son of Akhtabuddin and alias Aftab Ali,
my lord,
correct?
my lord,
So this is something which the petitioner does not say. And then in paragraph 5 of the same page, page 1 of DW2, he says, my name is Abdul Noor.
my lord,
Now he lives at, this is Elias.
my lord,
That Abdul Noor,
my lord, it is very common in Muslim community, my lord. Because they
no,
are very
we
limited
can't
person,
generalize.
my lord,
We can't generalize.
my lord,
It may be an instance, but it can't be a general proposition.
my lord,
I have many friends who have only one name. If they have any other, we don't know. Now, one of the classmates of Mr. Dey sitting here, no, don't stand up. Is a judicial officer now retired.
Mm.
He has only one name. He and Mr. Abdul Hakim. He has only one name. I don't know if he has any second name. He was a judicial officer, grade 1, he retired.
my lord,
This is one person I know. And therefore, it's not a general proposition that everybody would have a second name.
My lord, he is a judicial magistrate, my lord, and
No, you say when you generalize,
Mm,
you
my
have
lord.
said about Muslim community.
my lord,
When you generalize,
No.
then we can pick up any example.
my lord,
If I can show one,
my lord.
Prime Minister of Bangladesh, he has only one name. Sorry, the present one and the deposed one, both. We don't know of any other second name they have.
Sorry, my lord, but my personally, my lord,
Mr. Ali is sitting here. I don't know if he's any second name. And don't stand up. I don't know if he's any second name.
my lord,
And yes.
my lord. But sorry, my lord, my personal name has been wrongly entered in my voter list, my lord, my personal,
That's-
my lord,
No, that can enter, but when you say it is an
My lord.
alias,
My
then
lord.
you generalize by saying it's
My-
common in the community.
my lord,
It's not really acceptable.
my lord, my lord.
Although the Supreme Court in a case has observed it is common, but I can't say it is common.
My lord, point is that, my lord, the parents, father himself adduced evidence in support of her daughter, my lord, before
What
the
you
trial.
see, you see, that's why we are asking you to show
My lord.
us that.
My lord,
Page 26 is the, sorry, that DW2 which you are having. Incidentally, the statement on oath is paragraph 5. He says his name is Abdul Noor.
my lord,
But in his verification, he says Abdul Noor Babunia.
my lord,
He is, and that statement in paragraph 1,
my lord,
no, not paragraph 1, the names. Affidavit in chief of DW2 Abdul Noor Babunia, alias so and so. This is not on oath. It's the difficulty. How is that name relevant?
my lord.
In your case, why, how the name of your father is relevant? Where is the finding of the tribunal?
My lord, I know the tribunal is that, my lord, he adduced evidence to support her name with her linkage of her father. My lord, kindly see her school certificate, my lord, annexer. Annexer 4, my lord, was 19 and 20, my lord.
19 and 20.
19 and 20, my lord.
Did the school headmaster come and depose?
No, my lord, that's the reason, my lord. But it was issued on 8/1/1990, my lord.
8/1/1990.
My lord.
Yes.
Para 20, my lord, the relevant page, my lord.
Yes.
1990, my lord.
Yes.
The headmaster, my lord, has not come to the court, my lord. I don't have the knowledge, my lord, why the headmaster has not come to the court, my lord, but maybe he died, my lord. The issuing headmaster, my lord.
No, no, you see, if it is done by the headmaster, anybody can come and depose. The present headmaster can also come and depose.
My lord,
Because the law laid down by our court
my lord,
is that the school certificate must be proved by the authority.
my lord. That's the reason, my lord. But her father himself adduced evidence, my lord, in supporting her daughter, my lord.
Okay.
Lord, appearance is, my lord, in the PCR, my lord. The PCR, my lord. No, my lord. Prior to that, she has married, my lord. She has married with Rafiqur Rahman, my lord. There are 5 of her evidence. Her father is still alive, my lord. And there is no case upon her father and parents, my lord, regarding the citizenship, my lord.
Finding some difficulty in reading it.
Yes.
The handwriting is
More নাম আয়েশা বেগম, মোর বয়স 44 বছর, 44 years. মোর দেউতার নাম আব্দুল নূর, মোর মার নাম মৃত্যু, মোর ককার নাম মৃত্যু আফতাবউদ্দিন, মোর মার নাম রহিমা বেগম, আইতার নাম নিনি বিবি, মোৰ বিয়াৰ 2 বছৰ পিছত মোৰ ককাৰ মৃত্যু হয়। মোৰ ভাই কিন্তু পঢ়িব পৰা নাযায়। ভাই পাঁচজন ভনী বা ভাই ইনুস আলী, ইছাহক, ইয়াকুব, ইউসুফ, বিরাজ উদ্দিন, ভনী রেহেনা বেগম, সাহেনা বেগম, মাইনা। মই কপিলিপাৰ চিৰাজুল মক্তব স্কুলৰ ৪ৰ্থ শ্ৰেণীলৈ পঢ়ো। Only that part can be read, my lord. Handwriting is very poor, my lord.
Because you see, no, it's okay, we also find it difficult to read.
My lord.
But you see, the problem is that the school certificate which you are referring to,
My lord.
look at the document, your age would be how much?
In the year
ডিসেম্বৰ মাহৰ 31 তাৰিখত এই স্কুলৰ এতিয়া গ্ৰহণ কৰা শুক্ৰবাৰ শ্ৰেণী সেই মানে 10 বছৰ বয়স আছিলে 1989 so 1990 we'll take it
my lord.
31 December we'll
My
take it 1990
My lord.
so 1990 she was 10 years
10 years.
so she'll be born sometime in 1980
My lord.
if she's born in 1980 then
At the time of adducing evidence, her age should be, my lord, 42 or 44 years, my lord. 44 years, my lord.
see that because
There has been,
records are there
my lord, 6 years has been lapsed, my lord.
according to her
According to the
evidence
opinion, my lord.
in her evidence she gives her age as 36 years
My lord.
in 28/7/2016
My lord.
doesn't match.
My lord, if my lord peruse her evidence, her signature, my lord, she can hardly write her name, my lord. She read up to class 4, my lord. She is almost an illiterate person, my lord. In the signature of the petitioner, my lord, if my lord peruse her signature, my lord, it can clearly reveal that she hardly can write her name, my lord.
No, you see,
My lord.
ability to write name does not show ability or disability to write name.
My lord.
Does not reflect
My lord.
the IQ level of a person.
My lord.
But she, you see, she's asked, and therefore she is writing
My lord.
this age in the evidence on affidavit. Look at this, page 22 of the LCR.
My lord.
In the evidence on affidavit,
My lord.
at paragraph 2, she does not give the age.
That my present age is 36 years.
So that is written after that.
My lord.
That means it's a gap. Somebody asked her and she writes the name,
My
the
lord.
age.
My lord.
So and she's adducing the evidence of the school certificate. She can't say that
My lord.
she does not know the.
My lord, the evidence written in English, my lord, but she hardly can write her name in the Assamese language, my lord. The evidence is
Those things
prepared
we
by the.
may not comment.
But
It would be contrary to the oath.
my lord, evidence is prepared by the learned advocate of the trial court, my lord.
No, we understand, but it can't be wrong.
My lord. It should be read, my lord.
Nobody has complained
My lord.
that the person has signed without knowing it.
My lord.
Because we are trying to match
My lord.
the veracity of the evidence
My lord.
vis-a-vis the evidence exhibits.
regarding oral evidence of আপনার WBC 4020/2017.
Just now. 4020 is Aziz Mia.
Asia Khatun. Asia Khatun.
Asia Khatun.
Asia Khatun. ASI 4020/2017.
Asia Khatun.
Decided on 21/11/2019.
16.
Hello.
Twelve 8/2016. Ninety-nine is 2016.
my lord, evidence was well,
DW2, but there's a reference to DW2 in the opinion. See, this, it has to go back. You succeed by default.
my lord.
You see, that's why we always tell that if you want to do matters, unless you look at the TCR, no point, you can't assist us. You will not be able to assist us. And in the process, you will not learn. Then your only submission would be restricted to, since Lordship has the record, Lordship will pass the order. Just write heard. So that practice will start. Don't do that. We want the lawyers to shine in life, do good. Mr. Sharma, you're satisfied? Okay. Heard. Mr.
MH Sakia, my lord. MH Sakia.
Second and counsel for the petitioner and so on and so forth for the respondents. By filing this writ petition under Article 226 of the Constitution of India, the petitioner has assailed. Petitioner has assailed the opinion dated page 28, dated so and so, passed by so and so in so and so. They were declaring the petitioner to be a foreigner post 25 to 1971 stream. In view of certain discrepancy, which has discrepancy in the trial court record, which has come to the notice of the court in course of hearing, the pleadings and evidence on record have not been referred to in this opinion, in this order. Next paragraph. In paragraph 6 of the impugned opinion at page 29, the learned tribunal has recorded as follows. Para 6 to be quoted. Full stop. Next paragraph. On a perusal of the tribunal's records. It is seen that the evidence on affidavit by the petitioner as DW1 and the DW1 was shown before the notary on 28/7/2016 and was filed before the learned tribunal on 28/7/2016, which can be seen from the cancellation of the court fee stamps. So this said record is available at page 22 of the TCR. Most of the tribunal's questions to DW1 was recorded on 26/4/2017 at the back page of page 1 of the evidence on affidavit of DW1. Sorry, back page of page 1 and 2. Stop. The evidence on affidavit by DW2 was shown before the notary public on 12/8/2016, which is available at page 26 to 29 of the TCR tribunal's records. So, however, the date of filing of this said evidence on affidavit of DW2 is not recorded. In the body of the evidence on affidavit of DW2, although the court fee stamps is shown to be cancelled, but it bears no signature or date of cancellation of the court fee stamps. The presentation of the evidence on affidavit of DW2 could not be seen reflected in any of the orders passed by the learned tribunal in the order sheet. Full stop. It may be mentioned that as per the order sheet, as per the order dated 28/7/2016, the learned tribunal had recorded that the evidence in chief of DW1 was evidence in chief without any supporting documents was filed. Most of the order passed on 28/7/2016 does not disclose the two, could not be understood, and therefore the said order is quoted below. This is at pink flag of the TCR, page 2 of the TCR, 28/7/2016. So as per order dated 20. You see there, or this order dated 28/7/2016 TO2, order dated 12/6/2017 are quoted below. This is from page 224 of the LCTCR. Full stop. Next para. There is a reference to the filing of petitions in the order dated 29/8/2016 and 5/10/2016 was of Hava. Those two petitions which are available at page 44 and 45 of the TCR is a mere petition for adjournment. Full stop. Next para. Therefore, comma, from the extract of the orders as quoted above, herein before, travels records as quoted below. The travelers orders, the travelers orders as quoted here before, does not reflect the acceptance of the evidence on affidavit by DW2. First of, however, the travelers records, which was read with the able assistance of the learned standing counsel for the FT matters, did not disclose the availability of the cross-examination of DW2, but which is neither reflected in any of the orders quoted herein before. Or the reflection of the evidence on affidavit by DW2 and reference to his cross-examination is not borne out of records. Next part. Resultantly, the opinion, which is based on the non-available cross-examination of DW2, and the reference to the evidence on affidavit of DW2, which is also not found to be accepted in any of the orders passed by the learned tribunal, comma, the opinion, the appeal opinion dated 28/7/2017 is found to be vitiated by non-application of judicial mind. Next one, resultantly, comma, the court is constrained to remand the matter to set aside the impugned opinion dated 28/7/2017, passed by so and so and so and so, page 28. Resultantly, comma, the matter is remanded back for a fresh opinion after accepting the after acceptance of the evidence on affidavit by DW2 by the learned tribunal, and after giving the DW2 a reasonable opportunity to appear and to face cross-examination. Next para. The petitioner was represented through her learned counsel is directed to appear before the learned member, foreigners tribunal number 7th, Lanka, Nagaon. Positively on or before 7/11/2025. And by producing a certified copy of the order, await further instructions or orders of the said learned tribunal. Next para, it is made clear that in the event the petitioner does not appear on the on or before the date fixed herein before, it would be open to the said learned tribunal to treat the petitioner as absent on call and pass a fresh opinion in accordance with law. Next para. The registry shall send back the records of the tribunal expeditiously back to the concerned learned tribunal. Next para, the what to do? We intended to circulate this to all the tribunals so that everybody knows they will cure themselves. Should it be done or we should not do it?
I will communicate Lordship.
Okay.
After acceptance of evidence of DW2, this is already available on record.
No, not that. You see, we have retained this matter from 2017. So we are 8 years now. So we want that these tribunals should, at least before they are passing orders, at least they should look into the records and see whether they have, the order sheets are properly maintained, whether they have been actually examined or cross-examined. If they don't do these things and after 8 years, when we send back the matters, we don't even know whether the witnesses are alive or not.
Yes.
So the intention is not for any other purpose, but to see that when they are passing an opinion, some sort of judicial discipline they have to maintain. Next para. Have you noticed that for a procedural lapse of the learned tribunal, the matter had to be remanded by upsetting opinion rendered on 28/7/2017. It is expected that the foreigners tribunals in the state, before passing an opinion, should at least examine if all the records are in order and the evidence on the evidence on affidavit filed by the DWs public proceeding have been accounted for in the order sheet as to whether the witnesses have been cross-examined or examined by the tribunals exercise of power under Section 165 of the Evidence Act, corresponding to Section 169. Obvious action. 169 is legal. So 168, that will be 168 of the Bharatiya Sakshi Adhinayam 2023. And thereafter proceed to render an opinion in accordance with law. Accordingly, we request the learned standing counsel for the FT and border matters to transmit a downloaded copy of this order to the Home and Political Union Bracket B department so that it can be circulated to all the learned tribunals, foreigners tribunals in the state.
Deeply obliged, my lord.
17.
Yes, Mr.
My
Nandi.
lord, this item may kindly be passed over for today. Let it come in November first week, any day.
Both sides are represented. On the prayer made by Mr. D. Nandil and counsel for the petitioner, the matter stands adjourned today. List the matter on 3/11/2020.
Let it deeply obliged.
18.
It is my lord, case of custodial death, my lord. And respondent number 3 file affidavit in opposition, my lord. I 6 time, my lord, to file a reply, my lord.
In this case also you want to file a reply. Affidavit of respondent number 3,
Respondent number 3, my lord, file.
that was filed long back in February. Because they say that the cause of death is mentioned in the postmortem report.
Postmortem report, my lord.
And in the postmortem report, the cause of death,
Well, cause of death is due to hanging, which is, my lord, kindly see, my lord, page 44, my lord.
page
Page 44.
44, yes.
Affidavit in opposition, my lord,
Ah,
page
yes.
44.
Page 44, yes.
Opinion reflected, my lord, in our opinion, the cause of death is asphyxia
44.
due to hanging, which is
No,
suicidal
page
in
44 is something which is advocates legal opinion.
legal opinion.
Page 43, 44 is a legal opinion.
144, my lord,
144.
144, not 45. It is the final report, my lord. I have
yes,
another,
final
my lord,
report.
provisional report, but it is final,
No, final is in Viscera. Viscera is negative.
negative.
Then, the cause of death is asphyxia due to hanging. It's suicidal in nature. And antemortem in manner. Example examination of viscera is to be. So once it is dead during custody, whatever reasons, you will only be entitled to compensation under the scheme.
No compensation has been paid, my lord.
No, they will, because once you have come to court, they will wait
My
till
lord,
the opinion of the court, and then
lord,
if you,
kindly says some, my lord, discrepancy, my lord, regarding, my lord, injury, my lord.
you see, we have the only reason for telling you is that in this matters, if you wait for affidavits to be exchanged, and then by the time we hear it,
My lord.
the urgency is lost. So it's a case of custodial death at the time when he was in police custody. The things boil down to only payment of compensation under the act. So that the state does not say they will not pay. But when you are making an allegation that it was it's a police torture, then they are opposing it. And if you don't have any dispute with regard to that, why wait for a affidavits to be exchanged? It can be disposed of, directly compensation to be paid in accordance with their circular.
That's my lord.
Because once the death is there, whatever be the reason, suicidal or
To that extent, my lord,
you will have to
it's-
go by that
Yes,
circular.
true. my lord.
Where is that circular?
My lord, I have not. No, I have, I'll find this.
You will take it up day after tomorrow then.
Yes, yes. my lord.
You understand the meaning?
My lord.
Once you contest this matter, it doesn't take us anywhere. Because the opinion of the opinion is already there.
To that extent, my lord, we cannot object.
No, we understand, but still I need that circular.
My lord, my lord.
I think it is 3 lakh rupees.
My lord, it's 3 lakh. One or two cases are there where lordship has granted 5 lakhs. Those decisions are also there.
Oh, you're fair enough. And by the way, how's your health now?
Fine.
Fine, okay.
Post operative, those things are going on.
No, it's okay.
No,
Just,
that's fine.
I just saw you and remembered. Okay. Both sides are represented. This on. We say just on the prayer made by the counsel for the petitioner, this on. Day after tomorrow,
Lordship, 15.
15.
All right.
Item 19.
Lordship, this is an appeal, Lordship, prepared against judgment dated 4/11/2024, passed in WPC number 3664/2022. Lordship, judgment is at page 130. 130. Lordship, the basic facts of the case is that Lordship, on the petitioner, Lordship, who was an employee of the Jorhat Treasury, submitted an application for voluntary retirement on 20/12/2021. And that is available at page 40 of the appeal, Lordship. Application for VRS. It's a short application, Lordship, may kindly go through it, page 40. Yes, Lordship. 2012/2021. Lordship, it was submitted before a treasury officer. And the treasury officer, Lordship, on 24/12/2021 forwarded the same. On Lordship, on 24/12, it was put up in the file, Lordship. And on 27/12, it was forwarded to the Deputy Commissioner because Deputy Commissioner is the appointing authority. 27/2021, it was forwarded to the Deputy Commissioner Jorhat by the Treasury Officer.
24/12, it was put up in the file.
Yes.
Then
On 27/12,
2021,
2021,
2021.
it was forwarded to the Office of the Deputy Commissioner Jorhat.
Yes.
Lordship, DC Jorhat, Lordship, forwarded the file to the ADC, Lordship, for his comment on the same day, that is 27/12.
Yes.
And on the basis of the note given by the ADC on 24/1/2022. 24/1/2022. Note given by the ADC. And on the basis of that note, Lordship, on 9/2/2022, DC Zorat approved the VRS application.
9/2/2022.
Yes, Lordship. Deputy Commissioner approved the same.
Yes.
Lordship, that approval of the Deputy Commissioner was communicated to the petitioner on 28/2/2022 by the Treasury Officer Jorhat. I mean, the writ petitioner was intimated by the Treasury Officer on 28/2/2022 as regard the approval of the Deputy Commissioner for the VRS application.
Yes.
Lordship, subsequently, on 11/3/2022, a file was put up, Lordship, for sanctioning the retirement benefits in respect of the petitioner. Which was forwarded to the Deputy Commissioner on 14/3/2022.
Forwarded on
14/3/2022.
yes.
Subsequently, Lordship, on same date, Lordship, 14/3/2022, Deputy Commissioner approved, and consequently, the date-come retirement gratuity, LEB, GIS, and provisional pension of the petitioner was sanctioned, and it was granted, Lordship, to the petitioner.
What date?
14/3/2022, it was sanctioned or approved.
It was forwarded on 14/3, sanctioned on same day.
Yes, Lordship. Forwarded to the Deputy Commissioner on the same day it was sanctioned.
Okay.
And the sanction components are DCRG, LEB, GIS, and provisional pension.
DCRG.
DCRG, LEB, leave encashment benefit, GIS, and provisional pension.
Yes.
Lordship, on 35/2022, the present writ petition was preferred. 35/2022. Notice was issued on 36/2022. And the learned single judge was on that same date, Lordship, state that that communication dated 18/2/2022.
Yes.
Now, Lordship, in the while perusing the writ petition, Lordship, the Office of the Deputy Commissioner and the Office of the Treasury Officer first time came to know that on 21/12/2021, one letter was submitted by the petitioner for withdrawal of the VRS application filed on the previous day. So that was the basic ground in the writ petition. And it was Yes. Lot of affidavits were filed on behalf of the Deputy Commissioner as well as on behalf of the Treasury Officer, Jorhat. And in both the affidavits, lots of stand was taken that this withdrawal application was never received in the office, in the Treasury Officer. And to show that lordship, receipt record lordship was produced before the court. And it was in fact found that in that receipt or record lordship, there was no receipt of that application of 21/12/2021. Now, if lordship comes to the judgment lordship at page 130. It starts from page 130. Lordship, I am at page 136.
What is this interlocutory application for?
This is for staying the impugned order, lordship. Lordship, what I'm praying basically, lordship, admission of the appeal, lordship, and staying the impugned order, lordship, today.
But there is
One delay condemnation application was
that in this order, there is a reference to the an RTI application and the different documents being produced.
I
What is-
obtained.
What is those that is?
Let, my lord, see that, let me finish, I'll just show my lord. Let it
No, his,
Finish.
his,
argument is, but
his simple submission is only that we issue notice and therefore we have to stay the operation. Because that is a consequence of admission of an appeal.
yes,
We
yes.
just wanted to satisfy ourselves with that discrepancy in the documents. If you can just.
Yes,
adjust-
my lord, my lord. First, your lordship, if your lordship, please come to page number 41, the beer application. I'll just show my lord.
So when there is a dispute with regard to the,
That document,
no, with regard to the basic fact about the submission of the RTI or not, that has to be examined.
yes, the RTI application, my lord. If your lordship, please come to, initial, I'll compare this one. Page number of, my lord, this is order
41,
9,
you said.
page number 55, my lord, please come. Which has got relation with that RTI.
Yes.
Kindly this order, there is a memo number. 9/2/22 order passed by the Deputy Commissioner approving. Kindly see the left side, my lord, there is a memo number, lordship has seen, my lord,
Yeah,
829.
yes,
Lordship has seen this one?
yes.
And my lord, lordship, kindly see now page number 47. 47. This is the crux of the matter issue. Page 47.
Yes.
First of all, that application bear a submit, what forcefully taken from me. Next day, I have submitted application for withdrawal saying, I have lost my husband. I have got two daughters. They are doing medical courses. My son is doing engineering. You have taken forcefully signature in the evening. If I go for blood, how do I manage their expenses? So kindly consider this one. They have taken forcefully. That was the issue. And that was received by one Ajit Hajarika in the office who sits adjacent to my table. All along, he received it. But in the office, they don't maintain a system where they put a seal. They never maintain. He received this one. Now, why this was not put before the file? What was put before the file not shown? The reason lordship will kindly comes to page 47 now. I'll show from here. See the memo number and the date. 20th of February 22. Page 47. This is very important. Here is the crux. 28/2/20 is the date. And the memo number is 829. Lordship has seen? Please come to page 55.
Yes.
This is dated 9/2/22. My lord, 21 days earlier. See the memo number top left side. 829A. Normally in the office works, first number is used, then subsequently whatever comes ABCD is being done. Now can you please come to page 119. Because we have taken the plea that when the treasury officer passed the order, I am allowed to go on BRS, voluntary retirement, my lord. He simply wrote That order, my lord, just let me read once again, my lord. That's in page number 47, page 47. Please, my lord, page 47. Let me read. With reference to the subject stated above, it is to inform you that a petition for voluntary retirement submitted by you on 2012 has been approved by the authority. Hence, you are allowed to go. Who is authority? Where is the member number? Nothing is mentioned there. Simply the trade officer himself has done it. To cover up this one, now see the memo number 829. Now, Lordship has seen page 55. Memo number, which would have been earlier. Page 55. 829A. It has come 21 days before. And this 829 has come as after 29 days. Now come to page 129. How it will be managed, kindly see, my lord. 119. 120, my lord. One. Yes. It will start from page number 125. Kindly see. That is what I received from the RTA. Page 125. Translated copy of the, my lord. This is the Lord Mechanic. So. Original RTA I have got pro. This one, RTA got. It looks simple, but it's not like that. This is the register. Lordship, but same one I have placed it, the photocopy behind, below this, page 127 it starts from like that. But kindly see page 125. Type there, register of letter issued. Lordship has seen, left side is what, my lord? It's the memo number 801, 825, 826, 827. Please come like this to page number 129, my lord. Now please come to page 29. Here, Lordship will get what has happened. Left side, kindly see the number. Page 129.
Yes.
Come below, my lord. Now, Lordship will see there's a date 28 to 22. Lordship has seen this. Now, just below this, 829. In the left side, kindly see there's a column for numbers. What they have done, they have put the date 20 to 22. Below 8 to 9, it is which ought to have come, that order was passed on 28 2, that is 8 to 9. And 9th February, 21 days early, the memo which is below there, 829A. Kindly see, my, is it the serial they were maintained? This is a manipulated document. To cover up that one, when I raised the plea, the TO has passed an order to Treasury Officer with the approved authority. We said, which authority, no member number, nothing. Honorable single judge got to stay because of this. Now they have filed an affidavit where they have said, the Deputy Commissioner has passed an order on 9 to 22, but Deputy Commissioner annexed that copy, but see the memo number there, they've been caught. 829 should have been earlier, ABCD comes later. How come 829, A has come 29 days later, my lord? Earlier. This is the C from the RTA application. Lordship, see, it is not synchronizing. 827, 828, and then there's a date. Then 829 they write. Then again below 829A. See that below there's a line. It is there, my lord. And no other pages it is there, except in this particular 829 and 29A. Because of the date of issue notice, till filing affidavit, there are 3 months time they have got. Otherwise, why Treasury Officer did not make mention of the memo number in his order dated? The DC is approved by this memo number, nothing has been mentioned, only approved by the authority. Which authority, what's the memo number, what's the date? I said, I've got two daughters, one son doing medical courses, my lord. They have completed now MD, and the son has completed engineering. She said, how can I manage their expenses? Husband, she lost her husband, two daughters, one son. Luckily, the son is so intelligent, my lord. We'll be proud to hear, my lord. This boy he has gone to California to do a course for 5 years regarding engineering or arts, my lord. In 9 months, he has completed the course in California, and he was provided assistant professor in the California University. This boy, his name, everything came in the paper. He was, my lord, facilitated here in Jorhat. He was, my lord. This is the boy, this is the mother who did for them, my lord. Why she should take that BRS? It was forcefully taken. And kindly see, my lord, one thing. On 28/2/22, the treasury officer sent me saying it will be approved, you have to go to BRS. On the same day, selection committee was made, set. On the same day, selection committee set. The day I was removed, 28/2/22, page number 116, can you see? I'm just showing the ploy, how they made a plan to remove me from the post, being a helpless lady. 116, kindly see, page number. See, there's the date, 1/28/2/22. On the date I was removed, on that date, selection committee said, selected the members. There are 3 posts, back-end posts. There are subsequently, along with me, it came to 4 posts. They selected and another 15-20 days they fill up the post. When this honorable court passed an order to pay from my salary, I put an application for my salary. My lord, they said there is no post. How can it be there a post? Because you didn't comply with the interim order. And then you fill up the post, you were staying in the plea, there is no post. Where this poor helpless lady will go with these 2 daughters and my lord? Luckily, they're settled now. And this is the conduct of the authorities. My lord, this is the factual part. See the law point. Rule.
Lots of many allegations, lots of. Take on DW. Lordship, this was the record produced before the court, Lordship. This is only the photocopy right now, Lordship. Lordship, may kindly see the arrow, that blue arrow, Lordship. Lordship, that is date, Lordship, may kindly see 9/2. And that was the date on which the Deputy Commissioner approved the BRS application. 9/2/2022. The entire chronology is there, Lordship. Lordship, may kindly see from the first page itself. Whatever date I have stated, everything has been recorded there. Now, Lordship, this is a file moved from the office of the Treasury Officer to the office of the Deputy Commissioner. And when the Deputy Commissioner approved, Lordship, immediately this draft at page 55, Lordship, was annexed for signature of the Deputy Commissioner. Now, if Lordship comes to page 47, Lordship.
এটা
Yes, I'm coming to that. Just before that, Lordship, page 47. Page 47. Now, Lordship has seen their Lordship approval was definitely on 9/2/2022, Deputy Commissioner's approval. Now, if Lordship comes to page 47, I'm coming to that issue, Lordship. Page 47, Lordship. Page 47, Lordship. Page 47, Lordship, this is the intimation to the writ petitioner by the Office of the Treasury Officer, Lordship. Now, this letter has a Lordship date of issue, Lordship. It was issued on 28 February 2022 and issue number was 829. Now, Lordship, if I annex some document with this letter having the issue number of 829, definitely I will annex that number, give the memo number of 829A to that annexure, Lordship. Lordship will file that letter, Lordship, at page 55. Page 55. So this was signed on 9/2/2022, but as I have annexed this letter, along with a letter having a issue number of 829, the issue number given in this letter is 829A. So this letter was forwarded by the Office of the Treasury Officer, along with a letter having the issue number of 829. So the annexure of letter having issue number 829 is 829A. What is wrong, dear Lordship? Deputy Commissioner signed on 9/2, but I forwarded it on 8/28/2, along with a letter having issue number 829. Therefore, the enclosure is 829A. In fact, Lordship, this letter has 3 copies. This order dated 9/2/2022 has 3 copies.
Let us test this. You see, today we have passed an order.
Lordship.
A wants to forward that order.
Lordship,
B.
order was passed by the Deputy
No,
Commissioner.
I understand.
Yes.
We passed an order today. A wants to forward it to B. So A writes in the order, the letter issue number 1.
Lordship.
Now, will he put 2A in the order passed by the High Court? The issue number will never be there. So an enclosure to be numbered, it makes it questionable. We are not questioning you, no, not as an additional advocate general, but
No,
the
Office
proposition is.
of the Treasury Office, Jorhat, Lordship, use this as their issue number, Lordship. It may be correct or it may not be correct. But this is the annexure of 829, right? That is why it is 829A. That is their understanding, Lordship.
No, but a ranked junior treasury officer will give an issue number to a letter written by the deputy commissioner.
Yes, because the deputy commissioner's letters has no issue number, Lordship. It was given to the office of the deputy commissioner as a draft along with the file, that is the record, Lordship. Along with that record, this draft was forwarded. Deputy commissioner signed on the date on
This is
which he
what we
approved
were-
in the file.
This is what we were discussing.
Lordship.
We just discussed for a moment. The brother and sister had just discussed something. It was only this that we were very. Something would not have happened.
Lordship, moreover, Lordship, how can this become an issue, Lordship, when your Lordship has seen the record with the approval of the deputy commissioner, it was on 9/2/2022.
We will call for the records. The original records.
Lordship, definitely I will produce that. It is
My
the
lord,
photocopy of the
Lordship,
record.
please come to the judgment part, page 144, that order dated 9/2/22, when it is entered in the register or not, single judges, very nice dealt with, page 144. 144, yes. 144. Though a specific stand has been taken by the respondent that the deputy commissioner passed the impugn order on 9/2/22 and a copy was sent to the treasurer of Visa Jorhat to intimate the same to the petitioner. However, no receipt is reflected in the receipt register of such communication on the said date, that is 9/2/22, or any other date thereafter. In fact, there is no receipt of any letter in the receipt register on 9/2/22 from the deputy commissioner. From 10/2/21 till 2022, there is no different entries in the register showing receipt of different communication for the deputy commissioner on 11/3, 17/3, 6/4, 24, 4/5, 18/5, 27/5, 9/6, and in the meantime, on 3/6/22, the interim order was passed. The lordship single justice dealt with the records, my lord, seen. And the part which was given to your lordship, my lord, there was in between when I made the argument the first day, that in the impugn order dated 28/2/22, the treasurer passed the order asking me to go for BRS. He writes with the approval of the higher authority. No memo number, no authority, nothing, no date, nothing. When I placed that one, lordship was satisfied and that was the interim order. In between that, the 3 months time. So the record which given to lordship, my lord, that part I don't know. But the register which is maintained in page number 190, lordship is seen, left side is the memo number. But suddenly in that particular 8/20 date has number has come, date has come. It looks like, my lord, page 119.
We don't know unless we see, we don't jump to conclusion.
Now the contract, see, that's the reason I said, when my application was received on 21 by Ojit Hazarika, just like that way this is order was not mentioned there, like my application was not received, showing that receipt purposely, because if they show this one, the case gone. If they cannot throw me out, they cannot make selection.
That is also something which is, we are thoughtful about.
And I made
See-
that particular respondent as a private respondent, as a malified ground.
No, you see, you are working in that department. And therefore you are supposed to know whether there is an inward register and outward register. Correct. If that was not entered in the register, but some Ajit has received it, then you should have sent it by registered post.
No, the question is, like this, he sits beside me. I gave him, he kept it. When the case was filed, then my lord, they knew that ploy, so they purposely they kept it aside, but they put entry there, make the entry.
No. That's not the only point. The point is that this man who has received, was he authorized to receive it?
He is the person in the office he receives only. He only received the letters. 100 times I clarified from a client. He said, this is the table where he receives all documents, my lord. That's why Ojit Hazarika received this one. That's the issue. And if they receive this one, then that ploy will be, my lord, unsuccessful. So obviously, and see that memo number also, honorable single judge held, even this is letter dated was not entered in the register, my lord. So those documents which are given to lordships, my lord, these are official records, but in the register it is not mentioned there. Why? Because it is never came, it is not there, non-existent it was. My lord,
Yes,
can I?
Mr. Naik, by which date you can produce the this register?
Original, I am placing if lordship comes to page 83, lordship,
Page?
83.
No, that original register
Yes.
you are deciding your its production.
In fact, that was produced before the learned single judge.
Oh, that's
also.
okay, but that means you will be having it.
Yes, lordship.
When
Right now, I'm not having it. It was
This is-
returned, lordship. I will
okay.
again have to update.
This is from the Treasury Officer of
Treasury Officer Jorhat, lordship.
Jorhat.
Lordship.
So
If
they
lordship comes to page 83,
They
this
can
is-
transmit it within this week to you. They can transmit it this week to you.
lordship. Lordship, it will be produced, lordship, but I am just submitting 2-3 pages, lordship. One page 83, lordship. Lordship, this is the receipt register of November and 12, December, lordship. If lordship comes to page 84, page 84. Lordship, may kindly see that 2012-21. 2012-21. Serial number. This is the third from the bottom, lordship, page 84.
Yes.
That is her application for VRS, lordship, 2012-2021.
Yes.
Lordship, there is no record on 21-12, lordship. So this is the copy of the original record.
Twenty-one is referred where?
Lordship, 21 is not there.
No, this 21 is
21 is the purported withdrawal letter, Lord.
page.
Uh,
Oh, that withdrawal letter.
Yes.
He admits that it is they have not.
Not
entered
in
it.
record. So that is my only submission. Yeah, ultimately, the learned single judge also admitted the fact that on record, nowhere it can be seen that that letter was submitted to the office of the Treasury
That's
Officer.
not the only fact,
Yes.
because in the order, the conclusion drawn was that there's a possibility of that withdrawal because of the fact that 3 months the VRS acceptance.
Lordship, in
could not
fact,
have been-
those issues were decided in my favor. If Lordship comes to page 92, just 2-3 pages, Lordship, page 92. Page 92. This writ petition was filed on 30/5/2022. Lordship, may kindly see the provisional DCRG. The token number, Lordship, may kindly see 22/3/27, token number 15. So in the month of March, similarly, leave encasement, same, March. GIS, March. Provisional pension, May. Provisional pension for the month of May 22, same, May, in the month of May. Lordship, writ petition was filed only on 30th of May 2022. Lordship, all these amounts were deposited in the accounts of the petitioner.
I've got answer to this.
You preferred not to say anything. You prepared an application only on 30th of May. On 20th/12, you submitted the VRS application. From 28/12/2021 to till the date of obtaining an interim order by this honorable court, you preferred not to attend the office.
I'll make my answer on.
You
this slide.
accepted the VRS, you accepted the DCRG, you accepted the leave encasement, you accepted the provisional pension up to the month of May 2022. Thereafter, you filed this writ petition. And the reason also I can explain, Lordship. One reason is there. Because another officer was there in that office, Lordship, who had 2 certificates of HSLC. Ultimately, after retirement, rupees 16 lakhs was recovered from his retirement benefit. And that recovery was upheld by a learned single judge of our High Court, Lordship. Immediately thereafter, this VRS application was filed. But subsequently, she became wise, Lordship, definitely got some legal advice. And on 30th of May, she filed this writ petition. That is my...
So this lady also has 2 certificates.
Yes, Lordship.
That
She
is
has
the
2
correction.
HSLC certificates. That is her confidence.
There's also manipulation.
She has 2 HSLC certificates.
No department proceeding for that.
She has 2 HSLC certificates. She has 1 fake higher secondary certificate. she has 1 degree fake certificate. And all this has been, verified by the concerned authority and the
We were
college.
missing a link. So this is the link.
So that is the conduct. Poor lady lordship, I'm referring to.
No.
Repeatedly, he was saying
that.
that poor lady lordship, poor lady.
No, poor lady is okay. because
Poor,
you
see the conduct of the poor lady lordship.
You see, we have a beautiful Hindi song where it says that मुझको एरोप्लेन दिला दे एक नहीं दो चार दिला दे.
Adnan Sami, my lord.
No, whatever be, but even with 1 aircraft, people may think that they are poor. They need 4.
Lordship, to enter service, she requires a HSLC certificate. So she placed the HSLC. Now for next promotion, she requires a higher secondary qualification. She obtained another higher secondary certificate and it was placed before the authority. She got the promotion. Then for next promotion, Lordship, she needs a degree certificate. That was also obtained and it was placed before the authority. And most importantly, Lordship, her husband was the treasury officer of the same treasury. This is the conduct, Lordship. So what I'm saying at this stage, Lordship will admit this petition, appeal, Lordship. Lordship will stay the impugn order, Lordship. And
So for this, my lord, DCI, the other things are concerned, what happened, my lord? Nowadays, lordship doesn't get salary by cash, my lord. It enters in the bank account. They know my bank account. They put everything in my bank immediately. Other normally people come to the court and file cases for all these benefits, my lord. They put that one, and I file application for the treasury visa. Please take back. No notice was ever given to me that you are entitled for this. No document was given to me. You are getting this amount of money. Nothing. Just put in the bank account, my lord. They know the account because I get the salary. Account is there. Very tactfully, drama was planned.
It's okay, but
every single money comes to my account, Lordship. I give a message, Lordship.
Look, auto given me a notice that this is your entitled for this money. Nothing.
no, for treasury officer to send, they don't need a mandate.
Lordship.
For a treasury officer to push in, money in your account, you don't need a mandate. The single mandate when you become entitled to reimbursement from the treasury officer. For example, now you are a law officer, you will perhaps get it through the state treasury.
No, these days, Lordship, every officer gets their salary, be it salary or pension, Lordship, in the bank account only.
No. The reimbursement you draw as a law officer, perhaps it will be now sent to you by the treasury office. It doesn't come through the office of the senior advocate, senior government advocate.
All through treasury office only, Lordship.
Through treasury. So you will not need a every time mandate to get money in your account from the treasury. That's what I'm saying. Nothing on you personally, but for every transaction, you don't need a mandate now.
The amount is probably he cannot.
No, we cannot. We are something like colorblind. Cannot see many things, can't hear many things.
Lordship will hear this matter, Lordship. Today, Lordship will.
And regarding this point of.
Tell us the date when you are producing this original register.
One issue, my lord.
Can you produce it on 24th?
Today is 14, on 28, Lordship. 28.
28. Make it 27th.
28. Make it a bonus now.
Make it 27th.
27th, my lord. And I make my submission to one point, the legal point, my lord. When my appointing authority is the deputy commissioner, whether any other person can do this, my lord. Because Nazir Ahmed says.
That will examine.
Those things, that's the law point, my lord. Suppose application is addressed to the treasury officer. If it is wrong, I also file application to treasury officer. If it is wrong, Nazir Ahmed will look at us.
Lordship, order was passed by the deputy commissioner himself. He was only communicated by the treasury officer.
See that?
That's doubtful. The register says so, my lord.
This is produced by you, and this is produced by you.
Yes, yes.
This appeal you say. Heard Mr. P. Naik, an additional advocate for the state. Assisted by Ms. Harbour and counsel for the. Your government advocate?
Lordship, advocate, lordship.
The advocate for the advocate assisting. Assist advocate. also heard Mr. M. Nath and Senior Counsel assisted
AP Bora.
by Mr. Bora. So you have appeared by filing an caveat.
I filed my, this thing.
Color-
Proposal number subsequent.
Color number we have filed.
We have filed. Initially filed the caveat, but the date 3 months elapsed.
No, it's okay.
So subsequently filed the Galatama.
Okay. Assistant Mr. Bora, and counsel for the Mr. D.P. Bora, and counsel for the respondent. In view of the this intra-court appeal is directed against the judgment and order dated 4/11/2024, passed in WPC passed by the learned single judge in WPC 3664 of 2022, by which the writ petition filed by the respondent was allowed. Next para. Issue rule returnable forthwith. Achha, who will appear for this 2, 3, 4 and 2, 3 and 4? I think government advocate will appear. You're there? You'll be appearing for 5. And who is Mr. Hazarika? Will take notice on behalf of 120. The first responsible, I'm not for responsible one, serious one, assisted by a responsible one. Then you change the order. You just say, Mr. Pinaik, additional advocate general for the state, assisted by so. Then this inter-court appeal is filed against so and so. Then next para. Court is inclined to issue rule returnable forthwith without requiring any fresh steps to be, any formal notices to be issued. As Mr. S.K. Hazarika, and government advocate, has entered appearance on behalf of respondent numbers 2 to 4 and accepts notice for them. And Ms. P. Barwar, under counsel, enters appearance for respondent number 5 and accepts notice. Post. List the matter on. All the records are there. We don't have to call for the writ petition records.
Writ petition also may call for, Mr. Everything is here.
Everything is there.
Yes.
Okay.
Or in the same, if you also feel it, also can call for. It is in the same high court. If you also feel it.
All pleadings are here only, Lords.
Everything is here.
Everything has been.
He has annexed everything.
Everything is here.
Yes.
Is the dispute, it's, is it, is there is a disputed question of fact relating to the receipt and issue register maintained by the Treasury Office, by the Office of the Treasury Officer, Jorhat, correct?
Yes, yes.
Jorhat, yes.
Court is inclined to direct the state to produce the relevant receipt and issue register maintained by the Office of the Treasury Officer, Jorhat. Next, the learned additional advocate general shall communicate a order, copy of the order to the concerned authorities, just to enable the production of the said record. Next list on 27/10/2025. And the interlocutory application 3161. And PNAC under the additional advocation for the state. Issue notice on this interlocutory application for stay of operation of the impugned judgment and order dated 4/11/2024, passed by the learned single judge in WBC 3664 of 2022. Mr. H.K. Hazarika, Mr. M. Nath, learned senior counsel, enters appearance for respondent number 1 as Nath, senior counsel, assisted by Mr. D.P. Barak, and counsel for respondent number 1 accepts notice through his instructing counsel for respondent number 1, and Mr. H.K. Hazarika, learned government advocate, accepts notice on behalf of respondent numbers 2, 3, and 4, and Ms. P. Barwa, learned counsel, accepts notice on behalf of respondent number 5. Next para. Issue notice on this interlocutory application for stay of operation, which is made returnable on 27/10/2025. Stop. Till the next returnable date. Till the next date of listing, the operation of the impugned judgment and order dated 4/11/2024, passed in WBC 3664 of 2022, shall be kept in abeyance.
Obliged. Only one submission I have got, my lord. So far, this appeal is concerned. This my client will be returning, I think, in the month of January, February. And from the month of June 22, although the interim order, she goes to the office. They gave her a separate register. She put signature, but no work assigned. She's waiting all this along. If it is possible, my lord, an attempt should be made to dispose the petition. That's the only prayer.
We'll try to, but we can't bind ourselves. You never know what comes up here.
That's true. But I think just an attempt shall be made.
It's okay. You just remind us on the
At
next
least shall
day.
we satisfy either this year, that year, my lord, before retirement.
It's okay.
My lord. Obliged, my lord.
The problem is that here issues of fundamental rights come up.
Yes.
Police action also comes.
The
up.
previous
So-
case, like.
So we don't know what takes up our time.
I didn't say lordship shall, I said is a disposal of lordship.
No, definitely.
Obliged, my
But we'll
lord.
try to.
Obliged.
That is why I asked that question. 2 questions I asked. Those I couldn't follow. In the order of this reference to the fake documents, I could not follow this issue of the register. I couldn't follow. That's why I asked these 2 pointed questions.
Little tricky, like. Obliged, my lord.
So I think that we did, right? Oh, I'm sorry, we have to rise. There's a single bench. We have to rise.
Lordship, my item was listed as item number 34. Can it come up this weekend?
Before is a review petition.
Yes, sir. Lord.
Okay, please take. Review petition. Okay.
Let's just number 20, that maybe it's because he is petitioner in detained.
20,
20, I can remember.
20.
This year already received budget. 20. When it is
Make this both the cases on. Make it on 16th. Both these cases will come on 16th.
published.
Other matters will have to be adjourned. Issue notice
Lordship,
you filed your objection.
Lordship.
Uh, Heard the learned counsel for the, your name?
My lord, D. Roy. My lord, matter may be taken up day after tomorrow, lordship.
No, we are issuing notice in the bail application.
Lordship.
Heard Mr. D. Roy, learned counsel for the petitioner, as well as Miss
M. Decker,
M. Decker, learned counsel, appearing on behalf of
SC Case.
Mr. S. C. Kyal, learned standing counsel for the NCV. Next. Issue notice on this application for regular bail under section 483 of the BNSS. So, next objection, if any, be filed by the respondent prior to the next date of listing. How much time?
1 week time may be granted.
1 week's time.
My lord, can date may be fixed, lordship.
Our list of 27/10/2025.
My
Lordship,
lord,
I have small prayer, Lordship. Your trial court record will be necessary, Lordship.
It will be required.
Yes, Lordship.
Is the scan copy available anywhere?
Lordship. Pending assessment,
If this bench has rejected it, they will definitely be relying on the LCR.
Yes, Lordship.
Where
this
is
bench
that?
is rejected earlier, lordship.
Yes, Lordship.
When is that order of rejection?
All the rejection orders,
Page number 22.
22.
And 25, Lordship.
Hmm?
And 25, Lordship.
22, 25. Now again, 31 also is there.
Yes, Lordship.
51, then again 46. So Ms. Dekha, the witnesses examined,
Yes, Lordship.
they are also been annexed. Do you still require anything? The registry shall call for the for only that part of the scanned copy of only that part of record from the Court of Learned Special Judge Kamrup Amingao in connection with NDPS case number 23 of 2023, State versus Monirul and others, insofar as it relates to the the compliance of section 50 of the CRPC regarding the manner in which the petitioner was arrested without requiring any other documents to be produced, as the petitioners annexed the copies of several witnesses that has been examined by the prosecution. The registry shall also tag the records of BA 101 of 2023, disposed of by order dated 25/1/2023, as well as BA number 3343 of 2023. This is dismissed by order dated 16/2/2024, while it's listing the matter next. So we are only asking for section compliance of section 50.
Lordship, they have not annexed arrest memo, Lordship.
That's why it will come along with the section 50 arrest memo will also come.
Lordship.
Relative manner of arrest. That's what we have said. Do we need to write anything more specific?
No, Lordship.
That will suffice.
Obliged.
Manner of arrest. We have listed manner of arrest.
Obliged.
Highly obliged.
Here,
Item 2.
May I please, Your Lordship? Lordship, I beg to withdraw the petition, Your Lordship.
You want to withdraw it?
Yes, Your Lordship. I'm appearing on behalf of Mr. S.M. Abdullah, Your Lordship.
Okay. Miss
N.A. Begum.
N. Begum.
N.A. Begum.
N.A. Begum, Learned Counsel, appearing on behalf of Mr. S.M. Abdullah, Learned Counsel for the petitioner, has submitted that she has instructions to withdraw this appeal application. Accordingly, Mr. K.K. Das, Learned PPP is present. Next, the matter stands dismissed on withdrawal.
Obliged, Your Lordship.
Item 3.
Pen copy is not arrived.
Scan copy was called for, but it is not received. NDPS case.
Transmission. Mr. N.K. Morel, and counsel for the petitioner. And Mr. K.K. Das, Leonard, the APP for the state are present. As per office note, dated 22/9/2025, the requisition for transmission of the scanned copy of trial court records is seen to have been issued. However, as per office note dated 8/10/2025, the scanned copy of the relevant TCR is not yet received. Next, the registry shall send a urgent reminder to the learned sessions judge from Bongaigaon.
Karbi Anglong, my lord.
Karbi Anglong?
Yes, my lord.
Oh, it is sent to the wrong court then. No, so that's right. Yeah. We have said 8/10 because it has not been received. Next para. We take notice of the fact that as per office note dated 22/9/2025, the requisition for records has been sent to the learned sessions judge, Bongaigaon, whereas the case relates to NDPS case number 18 of 2023 arising out of Delhi police station case number 37 of 2022, which is under the jurisdiction of the Mr. Murray, what is the name of the court?
My lord, special judge in the PS Karbi Anglong, my lord.
Within jurisdiction, special judge, NDPS, Karbi Anglong. Just say PS case number 37 of 2022, corresponding to GR case number 261 of 2022. NDPS Act, NDPS corresponding to GR case number so under section 21 within bracket small c oblique 29 of the NDPS Act. Pending before the special judge, NDPS Karbi Anglong default. Next, accordingly, an urgent requisition shall be sent to the learned special judge, NDPS, Karbi Anglong, Difu, for transmitting the scanned copy of the case records by email for being placed before this court. Including scanned copy of notices public arrest warrant issued under section 50 and 50A of the CRPC, as well as production orders passed by the consent court, so as to enable the court to examine whether the law in that regard has been complied with. Next para. This order shall be brought to the notice of the DOJ. What is this bill section? Bill section would be? Huh? Criminal appeal section. Just call them and tell that, huh? They've sent it to wrong court. We had asked for the requisition of records. It has gone to District Judge Bongaigaon instead of Karbi Anglong. Just telephone them and tell them. Next para. List on. Last date we have fixed on 27th. I hope it's true.
My lord, can I just pray, my lord, small
Yes,
prayer?
yes.
Just accommodate me if possible, short date, my lord.
We are giving a shortest possible date
Yes.
because 3 days is again this Diwali holiday.
Yes, only on 16 is fixed, my lord.
27th. 27th.
Applies, my lord.
On 27, 10, 2025. I'm requesting the court master to send a
Lordship,
urgent
lordship.
requisition.
27